When anti-gunners pretend to care about democracy, that is exactly what they do. They pretend to care. There's no better example of this than what's happening in the Commonwealth of Massachusetts, as reported by the owner of Cape Gun Works, Toby Leary, who I've often been interviewed by on the Howie Carr show out of Boston. You're not going to believe what he's reporting as to what the governor of that state, Maura Healy, is intending to do this week. It's terrible, terrible, unconstitutional, dirty pool in my opinion. Let's break it down when we get back. You're not going to want to miss this one. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the book, Israel Disarmed, What the 10/7 Attacks on Israel by Hamas Teach Americans About the Right to Bear Arms. Check it out on Amazon. All right, folks, so we have breaking news, major breaking news by Toby Leary. I'll put a link to his breaking news down below from the Cape Gun Works gun company there in Massachusetts about what apparently, according to reports of Mr. Leary's, what the Governor Maura Healy of the state of Massachusetts is intending to do this week, which is to circumvent, get around a referendum opportunity or option of Massachusetts residents to stay, if you will, to freeze insane, crazy, and what is likely unconstitutional legislation enacted by the state of Massachusetts. Let me put this into some context, and then let me tell you what, according to the reporting, the Governor Healy intends to do there in Massachusetts against America's gun owners. To begin with, back in July, there was a crazy 120-some-odd page gun bill, anti-gun bill, gun control bill, enacted by the state legislature. Now, this is something that apparently, according to reports, took like 2 years to put together, so it's not like something that was thrown together overnight. You'll see why that's important in one moment. So this took a long time to write this up and prepare this bill, and finally enacted after much negotiation. It was passed in July of 2024. Now, under Massachusetts law, and this is key, at least according to many reports, including the Massachusetts' own webpage, when a law is enacted by the legislature, it usually takes somewhere around 90 days to go into effect. So this 120-some-odd page gun control bill would have gone into effect about 90 days after its enactment. Okay? Why is that relevant? Here's why it's relevant. Because also under Massachusetts law, there's an opportunity for citizens of that state to put together a petition and try to procure a sufficient number of certified signatures from Massachusetts residents who really oppose the law, or at least want that law to be put on pause before it goes into effect. And if they get a sufficient number of signatures, and I'm not a Massachusetts lawyer, but I'm going to give you the gist of what happens here. If they get a sufficient number of certified signatures that says this law should basically be reassessed, if you will, before it goes into effect, then what happens is that law is stopped or stayed pending the next election in the state, really giving Massachusetts residents the opportunity to weigh in on a major policy item that the legislature had enacted. And now that is what was going on. So ever since this law was enacted in July 2024, gun rights groups and other people, including Toby Leary, have been out front saying we need to collect a sufficient number of certified signatures in Massachusetts to allow everyone in the state to reconsider this and not let it go into effect, because if it goes into effect, a lot of gun companies and gun dealers in that state will likely go out of business. It will destroy their business, because this law enacted by Massachusetts is very wide-ranging. It codifies certain quote-unquote assault weapon bills or assault weapon interpretations into the law. They expanded even further to go after semi-automatic rifles and I believe even semi-automatic shotguns. They codify the 10-round magazine limitations. They expand the definition of ghost guns, which of course is a political propaganda term for privately made guns or unserialized guns. They do certain regulations on that. And they have all sorts of issues associated with quote-unquote sensitive places and so on and so on. I won't break down all the details. I'll put a link to actually an excellent article about this by Stephen Kotowski in The Reload and his colleagues over there. I'll put a link to it so you can check out the details. But the bottom line is this is a crazy anti-gun law that threatens the gun businesses and threatens, Massachusetts gun owners in a terrible way. So obviously they wanted to have this reheard by the people of the state of Massachusetts and not have this thrown down their throat. And they were going through this petition process to have it stayed, meaning to put on pause. Now here's where the curveball comes in. Apparently under Massachusetts law, there is an exception to this, which is that if the governor, hear me out, if the governor signs an emergency preamble that declares that in her view, there is an emergency that requires the law that was just enacted by the state legislature to go into effect immediately, then she's to sign such a preamble, an emergency preamble document, and deliver it and serve it upon the Secretary of State of Massachusetts, and upon the delivery to the Secretary of State's office, that law will go into effect immediately and thus, in effect, circumvent the opportunity for we the people in the state of Massachusetts through the petition process to stop the enactment of the law. Well, according to the reporting of Toby Leary and what he's been hearing, according to his reporting, he has heard that Maura Healy, who is a known crazy anti-gun governor, she was a crazy anti-gun attorney general. You'd expect nothing less in Massachusetts government, of course. She apparently intends to sign this emergency preamble on Wednesday to make this law go into effect and thus prevent the petition process from having any significance. Even though, based upon the reporting that I've seen, there's an excellent chance that the sufficient number of signatures were going to be forthcoming, identified, and submitted to the state that would have stopped the enactment, or not the enactment, but the effectiveness going into effect of this law until the next statewide set of elections. But she's going to short circuit this, circumvent it, and shut it down by this emergency preamble. So let's talk about, if she does do this, what are some of my thoughts on this? Now, again, I'm not a Massachusetts lawyer, and I haven't studied this backwards and forwards. I'm sure that the gun rights groups there have excellent lawyers in Massachusetts looking into all the details and probably are much more sophisticated on the area than I am. But I'll give you some general impressions of how I might think about this if I were in Massachusetts. The first thing is I would look very carefully as to whether or not the governor can really declare an emergency based on the facts on this record. And what do I mean by that? An emergency, obviously, is an emergency. And what does that mean? Oh, I don't know. Let's think out loud. 9/11 was probably an emergency, right? A terrorist attack. Maybe the Boston Marathon bombing was an emergency for a short period of time while they were, trying to find those two individuals who had done the bombing. I would say a winter storm, a hurricane, some crazy natural disaster like we're seeing in North Carolina right now would be the kind of emergency I'd be thinking about. Maybe COVID was an emergency for a period of time. Whatever it is, what does not appear to be an emergency is the situation with firearms in Massachusetts. Massachusetts has already had some of the nation's most strict, terrible anti-gun laws on the books for quite some time, including a quote-unquote assault weapon ban, thanks to interpretations done by Maura Healy that the U.S. Supreme Court did not touch, ultimately. So I wonder whether or not this is actually an emergency. Now, keep the other thing in mind I would maybe note is that the Massachusetts legislature apparently had the authority to put into the law they enacted in July emergency language to declare that there was some emergency that required this to go into effect immediately. But it sounds as if the state legislature did not put that emergency language in there, which seems pretty strong evidence that the legislature did not think there was an emergency in July. Now we're only in September, the start of October. So what's changed between the enactment of the law in July and today? Now, what I might do if I was representing the gun groups, if I were representing them, I might be looking to a lawsuit in state court in Massachusetts, maybe somewhere in the western part of Massachusetts, which is far more conservative than the East Coast Bostonian, Nantucket, Cape Cod folks as a general matter. But again, I'm not a Massachusetts lawyer. I'm sure they know the good venues in that Commonwealth. So what I might be doing is to look for a challenge in state court arguing that Maura Healy, the only emergency in that state is from the subjective political cynical view of Maura Healy, who realized that she was about to get bent over and spanked by the gun rights groups that had pulled together a petition with a sufficient number of certified signatures that were going to shut down her pet bill. And certainly it's not an emergency enough to get the legislature to call it an emergency, because they could have done that in the bill itself when they enacted it, but they didn't do it. So now you just have Maura Healy acting like a tyrant, acting like a totalitarian, authoritarian leader, declaring something an emergency when all it really is pet peeve. And I would maybe sue her in state court, and we're going to get to federal court in a moment, which I would not go to. I wouldn't even think about federal court. We'll talk about that in 1 minute. But I would look to Massachusetts state court, and I would basically go along the lines of saying there is no way on earth that there's an emergency that Maura Healy can identify. She can use, and again, she's got to, I would put her to the test and say, what exactly has changed since July of this year and October 1st of this year? What has changed that gives rise to an emergency between the enactment of this and the time she signs her emergency preamble, assuming she does so? The only emergency is in her mind. And that emergency is she's about to suffer a political setback. Well, she's used to political setbacks. I think she's had other political setbacks in the past, and she survived them, as did other people. So there's no real emergency here, and I would argue that there needs to be an objective definition of an emergency. Something involving the physical environment, something that's real, something that's not something, it can't be something that's been going on. And her arguments about quote-unquote gun violence have been going on for literally a decade plus probably. So it can't be that, because that's been going on for a long time. It's not an emergent situation. If it's not an emergent situation, it can't be an emergency, right? It's nothing unprecedented here. So I would be looking to sue in a friendly jurisdiction to shut down this law on the grounds that Maura Healy's declaration of an emergency is simply inadequate under law, and that the petition process should continue and should be respected, and that the governor cannot just simply do this like a king and declare whatever she wants to be an emergency. There has to be some objective criteria here, especially when it comes to a situation where the legislature refused to call it an emergency. And I might even, as part of the lawsuit, have favorable members of the Massachusetts legislature sue on behalf of the legislature to say, we considered declaring this an emergency and we chose not to do it. And we don't want the governor to have the authority to declare things an emergency when the legislature already said it wasn't only a month or two ago. And nothing has changed. Nothing has changed in Massachusetts in any material way since, of course, the enactment of the legislation. Because again, she doesn't want to suffer a political loss. That does not constitute, objectively speaking, an emergency. So that's what I would be looking to do. But again, I'm not a Massachusetts lawyer. I'm sure they have people much smarter than I am up there figuring this out. With that said, I will tell you one thing I would never do. Okay? Now, this may sound harsh. Some people may not like it. But you know, on this channel, I call it like I see it, and sometimes that's great news, and sometimes it's not great news. I would really not go to federal court on anything here. I know it sounds terrible to say this. I might threaten to go to federal court and basically say to the Massachusetts state courts, don't make another mistake like you did with the Caetano case in 2016, where in 2015, the Massachusetts version of the Supreme Court of Massachusetts upheld Jamie Caetano's conviction for possession of a stun gun and upheld Massachusetts law, only to see in the spring of 2016, the United States Supreme Court basically say that what they had done was a violation of the Second Amendment. Now, I'm happy to report that it's pretty clear that the Massachusetts Supreme Court is very concerned about another major setback by the U.S. Supreme Court. They seem a little skitterish, as well they should, that they don't bend over backwards to screw up the Second Amendment and the right to keep and bear arms. And the fact that there are people in the state of Massachusetts that are going to lose their business and livelihood if this law goes into effect immediately, if that's true, well, that would be irreparable harm, and that would be certainly something that I might point out in court. But with that said, I would not go to federal court because, as you know, I've told you repeatedly, the United States Court of Appeals for the First Circuit out of Boston, Massachusetts, is 100% the worst court in America when it comes to gun rights. 100% the worst. They're worse than the Ninth Amendment. They're worse than the Fourth Amendment. And the reason why they're worse than the Fourth Amendment and the Ninth Amendment is because the First Circuit, there is literally no combination of three judges for a three-judge panel that could conceivably be considered anywhere near favorable to the Second Amendment. They're all awful. And to make matters worse, the First Circuit also has relatively smart judges. So not only will they rule against you, which will cost you money, it will also set bad precedent, and the bad precedent will be ridden by judges that are going to work really, really hard to screw up the Second Amendment and the right to keep and bear arms. So there'll be no upside at all to go into federal court really with almost any argument. Well, I'm not going to say any argument, but just about any argument, I would say, and have any hope of prevailing. But again, I'm not looking at every detail. I don't know all the facts. So, maybe there's some reasons why I'm wrong, but I'm just telling you my overall impression is I'd be looking to do something in state court and not federal court if it were me. But again, I'm happy to be proven wrong and be told that I'm wrong, and it's certainly possible. These are just my impressions as we stand here right now. So anyway, folks, I hope our friends in Massachusetts find a way out of this. It's terrible that you have to be ruled under the thumb of people like Maura Healy. It's terrible, but it's a terrible jurisdiction. We know this. Everyone knows this, and hopefully, and I'm going to give you some hope, and that is this: that a lot of the issues that Massachusetts is trying to oppress our brothers and sisters in that state that own guns and that sell guns. The good news is, in time, the United States Supreme Court, I think, is going to resolve favorably a lot of these issues involving 18, 19, and 20-year-olds and guns, involving quote-unquote assault weapons, magazine issues, ghost gun issues. I think over time, in the next year or two, the U.S. Supreme Court is going to get it right and rule in favor of the Second Amendment on a lot of these cases. Now, that may be too late for a lot of people in Massachusetts with respect to their business. Maybe it's too late for certain gun owners. I can't solve all the problems of the world, but my impression is there's some good news coming down the road if you can just hold out a little bit longer. But again, it's really difficult for people in Massachusetts, and I hate to see what's going on with our fellow gun owners in light of the fact we have a Second Amendment, but there are terrible states out there with terrible politicians that don't respect the Constitution, and we don't want to see anyone in Massachusetts go to jail or get in trouble. So unfortunately, you're sort of stuck complying with these terrible laws, and it's most unfortunate, but there is no easy short-term answer that I can see other than maybe go to, if she signed such an emergency preamble, is try to get that enjoined and stopped and stayed on the grounds that it really is not an emergency, and the governor has to articulate an objective thing and provable emergency in order to circumvent the petition process that is ongoing. But again, I'll be watching this and seeing what happens, and I hope the lawyers in Massachusetts that are working on this find a way to solve all these problems. I certainly am cheering for them, but again, these are my impressions, and let me know in the comments down below if you agree or disagree with my opinions here. Okay, folks, make sure you follow me on X at 4Boxes Diner. Make sure you like this video and subscribe, and we will talk to you again very, very soon here at the 4Boxes Diner.
Orders up. Table 2A.